Good morning, everybody. I am Leonardo Seri. I'm an Italian lawyer, intellectual property lawyer. And here with me it's Antonio Di Giorgio. Please.
Thank you, Leonardo. Hi, everybody. I'm a lawyer too, but I'm focused on the regulatory market. So, MiCAR application, markets rule, MiFID, and something like that.
So we will try to address the application of NFTs in the music industry from two perspectives. The first perspective is copyright and IP issues, which is particularly interesting in the field of music, I would say layered and complex in the field of music. And a second step would be into financial regulation markets, financial regulation issues in order to understand what happens when we create a token in relation to the music field, which we may have a lot of applications, as you probably know better than us. So, do you need spaghetti ETH? Okay. So, you already know what an NFT is about. Basically, it is about metadata, which can in some way identify uniquely a digital asset, a file, for example, its location and enable its transfer through smart contracts, which can be in some way automated and decentralized, more or less, on the blockchain. That means that we can have many interesting aspects about that. First of all, if you think about music and copyrights, the date of creation of a work, and some transparency and clarity on ownership of rights, authorship, and so on. So information is in some way printed there and traceable in the circulation of the rights or of the good. That may be physical or digital. In this case, probably mostly digital. You can organize a sort of automated and decentralized remuneration mechanism. As you know, you can get shares from the circulation of the asset related to NFT, and you can use it for many kinds of applications. I would say, for example, with the community or for events, and in relation to the track itself. Is it just the first question is it a certificate of authenticity? Probably someone would say yes. I would say not per se. NFT cannot constitute per se a certificate of authenticity because of the fact that this kind of original sin. You never know who is putting there the information, so who is minting the NFT, and if the information minted is true or not. If I mint an NFT related to a track, and I'm writing there that I'm the author, and maybe it's Justin Bieber's song or whatever, there is something circulating through NFT on the blockchain, which is traceable and modifiable and whatever, but obviously the information is not a correct information, it's misleading. So I cannot grant you the authenticity of the information at the beginning, but I can track the information from the moment I put it in the system, from the moment I mint it on. So that's the moment from where I can use it as a certificate of something. It can be used as a certificate of authenticity, but it depends on the reliability of the subject who is minting the content. That, let's say, who is minting the NFT, because the NFT is just linked to a content which is external of chain, is not inside the NFT. That clarified, what about music? What kind of uses you know in the music industry of NFTs? I ask you, if you want to just raise your hands and reply. feel free. Yeah.
Okay. As a digital collectible, they can be used as representing royalties of some songs. It can be used as representing the rights, maybe copyrights of different songs. That's pretty much what I would say the most important one.
Others?
To share royalties, of course. For ticketing, I really like the idea for ticketing with NFTs and music.
Thank you. Others? Okay, that's all true. But with many other applications, you can use it, as you said, for ticket for concerts, ticketing, but you can use it just to have a stronger relationship with your fan base. For example, you can use the NFT for some extras or experiences like meeting the creators or the artists or in private or in the backstage, so kind of experiences. Your collectible pieces like also, CDs, like with the signature of the artist or stuff like that. So something which is collectible, limited, physical, not really granted in their uniqueness by the NFT, but in some way connected to the business operation or marketing operation you are conducting with through NFTs. As you said, it can be a way to represent the ownership of or co-ownership of copyrights, and you can sell copyrights or part of your copyrights to people who are buying the NFTs related to the single shares of copyright or the single rights related to copyright, or other rights. Think about, someone said shares on royalties. Think about it. You're not, it depends on the agreements and clauses and whatever, but basically when you are selling to someone the right to have a share on the royalties that are coming from streaming, for example, of a track, because it's related to the track then, what happens there? You are not selling, you're not transferring your copyright. In such case, you're transferring, and this is something that is not very clear. We have people who buy this and think that they have the copyrights or a share of the copyright. That's not right in theory, because they would have a right to a credit related to the copyright. So someone else is exploiting the copyright for example, the streaming, so the economic exploitation of the song, of the track, but you perceive, you get back something, which is a share on the income they have. So you have no right to do the streaming autonomously from the right owners. That's very important. You have to know what you are buying. If I have shares on royalties coming from streaming, I have no rights to start by myself another project of streaming of the track and earn something from that. I'm just getting some money from someone else who is organizing and dealing with the streaming, for example. That's very, very interesting. You can...
I have another application. I'm thinking, you can use also the NFT as a means of payment, like a form of bartering. I've seen also similar aspects in the market. But all of these different cases and uses of the NFTs have legal aspects behind it. So maybe I have heard also in the past the expression "the code is law." It's not only this. There is no legal aspects. There is a legal aspect underlying the code, but also we have lots of regulation, such as intellectual property, and also I don't know, MiCA regulation that maybe apply to the NFTs, because the application of the NFTs, Leo listed now just an example, but it's not a close list of the potential use of the NFTs.
You have many potential uses, yeah. Another interesting use, it's not the pointer, no, sorry, is this one. support and financing to emerging artists, not necessarily emerging, but there are people who are financing themselves as musicians, as artists, just selling shares of ownership of the tracks they are releasing, like through X or through other platforms. So they couldn't find a way to work as musicians or creators in the market, in the ordinary market, in the traditional market, but they found a way to create their own fan base who is supporting them and letting them survive and actually have good earnings through other platforms using NFTs as a sort of monetization of their creativity and their work. So that's possible. And someone said at the beginning that the main application or the main innovation of these instruments, I would not say so. But basically, it's something that is working and is. But just to reconnect to what Antonio was saying, that's very important to know from a legal point of view that all this stuff, it's if you want to start a project, it's just a sort of different ways to create some business using NFTs in the music. And one can think that, okay, that's all. I organize the platform, terms and conditions, and that's all. Maybe an agreement with a partner, and that's all. That's not all. Each one of these different applications has different legal implications because of how you treat the NFT. In some cases, it may fall, it may become a sort of payment instrument. In other ways, it's just a ticket. In other ways, it's just about ownership, so property rights, and that's all the issue if I can have property rights on a digital file or not, which is still discussed. In other cases, it's not about ownership of property rights, but about copyrights. In every cases, however, from my point of view, because I deal with copyrights and trademarks and whatever, he deals with all financial regulations, so it's very different fields, but very related, deeply related in the music industry. The important stuff on the other side, for those who buy an NFT, and for the minter, of course, who is searching for someone to buy his NFT, it's very important to know from the second hand what you are selling. From the other point of view, what you are purchasing. Because if I buy an NFT and I'm thinking that I have the copyrights on that song, and then I use it and I exploit it commercially and whatever, and I did not buy the proper copyrights for doing that, I'm an infringer. Basically, this is the issue. So it's very important to understand what you are buying and what you're doing with your NFTs. That's just some example, the first Italian example. Another way, it's just during a concert, Achille Lauro tracked and recorded its heartbeat and transformed it into NFTs. They were sold after the concert, and the earning was donated to an hospital, so like a benefit operation. This is a ticketing case. You all know Coachella, where a couple of years ago, some tickets were released through NFTs, through a platform that you all know. And when the platform failed and was closed, the people who bought the ticket, who was organized to be long-lasting for all your life, well, just were not accessible anymore. I mean, the NFT was existing, but you had no more connection with the content of the NFT. So you could not access the content of the NFT, the related content to NFT. That's very interesting because it's the other side of the coin. But also Come Cose did a lot of stuff. Come Cose, it's very interesting what they said. We have many other examples like Billie Eilish in 2022 or with a digital concert, and she was releasing NFTs for particular experience during the concert and whatever. Even Snoop Dogg used NFTs in music. But Come Cose said that's an interesting thing, which is another aspect, innovation in the field of music. With NFTs, you can univocally identify a song, a track, not just for the fruition of the song, but in order to prove that you are the owner of that song, that particular track, which is the one which is considered as original, signed some way, authenticated by the singer or by the player or by whoever it may be. So that means that you are applying uses that are typical of figurative art. Think about portraits, okay? You're applying that to music, which was not used to it. Okay, there is some collections of the CD or vinyl, whatever, but this brings it to a higher level. You can use it for digital collectibles, like real portraits, but in the field of music, for the digital file. You are not interested in the fruition, in listening to that track. You are interested to having it in your wallet and say, I have the only piece or the limited edition piece signed by, authenticated by the author or the player, whatever. Okay, this is another case, blah, blah, blah. That's not in the music field, but it's just to give you an idea of what you can do. You can just do something like limited access experiences or rights. For example, here, if you are the owner of CryptoPunk, well, you could buy the NFT limited edition created by Tiffany. The same you can do with music. You can access some tickets or gifts or other rights or goods, etc. if you are owning another NFT that I released or someone else released before. So it's like a club. You buy the NFT and you enter a club with access to particular experiences or rights. Another interesting thing is CI, Italian Collecting Society, who in 2021 anticipated that is working in collaboration with Algorand to the tokenization of copyright of artists and musicians in order to, the project, we have not many information, just a few information released by CI at that time. But they say they're working to this project, which should be, in its aims, an open platform to allow all the people, all the stakeholders to enter the system and use this platform to deal with copyrights, shares of royalties and whatever. You know that in the music field there are a lot of rights linked to each other and overlaying and so on. You could automate, decentralize, and efficient and make it more transparent, their management through such kind of platforms and using NFTs, even multi-signature wallets and whatever you may need to make it work. And that's something on something CI is working on. We don't know as of today how is going the project, but obviously is a long-term project, not just a short term. So let's see what will happen. But I think that this is the more interesting aspect of NFTs applied to music field. Not just the financing of the emerging artists, but the possibility to put all the players of the market, of the music market, together on the same infrastructure in some way, and let them cooperate in order to create an efficient and transparent and decentralized way to deal with artist rights. That's very interesting, but very, very, very demanding and very difficult to achieve. And obviously, the fact that databases with all the rights that collecting society have, they are not very updated. They are not very clear sometimes. I mean, sometimes there are some doubts about who is owning what, especially in co-ownerships and whatever. This not helps. Okay, perfect. So you can talk to CI and collaborate. No, that's very interesting. I mean, they are not the only player. A lot of players, probably like you, are trying to do that. The difference is they are a collecting society. So in Italy, they have like no more monopoly, but they have the biggest part of database of music rights, copyrights, in the Italian industry at least. And they've form a collaboration with other institutions. So it's, yeah. Talk about your project and this.
No, I think that's really complicated because there are many stakeholders in order to make this happen, and there is a lot of conversation from a legal point of view, technological point of view, tokenization point of view, as you were explaining. But it's happening right now. We were explaining in our talk that the market is ready for this abstraction to happen, and we will try to be one of those.
Tell us your name and the name.
I'm Gordo, and we were like the pitch before this one. We were creating a platform called Songs, which is like the first product on top of a product called Royalties Protocol. And it's specifically focused on digital distribution, on digital recordings, and exploitation of these copyrights. So we tokenized the song on its own, and the rights on top of the song, just on digital distribution, streaming.
Thank you very much. No, that's very interesting. So if you want to add something and tell something, just feel free. Just raise your hands, and it's kind of participated workshop. So
yes, because this is a workshop, so it's nice to interact with you. Also, we are 10, and so also we are lawyer. Maybe we'll not the scope of the speaker is not to annoy you. So if you have some specific topic, you may be curious in something. Also, in the legal aspects, we are here.
yeah, just if you
For free, because
that's the disrupting stuff of music and NFTs. So we already talked about that. What am I buying when I buy an NFT, especially in the music field? Well, it depends on what. First, terms and conditions of the platform. You have always to check the terms and conditions, and if you have the platform, you have to carefully think about what you are willing to sell. Second, the applicable laws. Just to make an example, in Italy, the transfer of copyright shall be demonstrated in written. That means that if you want to sell a copyright to someone, you shall do it in writing, otherwise you cannot prove the transfer. So the new owner cannot prove the transfer. That means that it should be in line with the terms and conditions of the platforms, and it should be clarified in the offer for sale and in the smart contract connected to the project, to the transfer, or to the NFT. That seems to, I mean, you may think that it's obvious, but if you just have a look to the many cases we had before courts, so lawsuits about that, and they are just a few, the more related to what we are talking about today, you can see that it's not so clear, it's not so obvious actually. The more interesting here are rough records, Rockefeller Records against Demon Dash, because Demon Dash minted with probably Superfarm some NFTs on the album Reasonable Doubt, which is a very famous album of Jay-Z. They are shareholder of Ref Records, but he tried to do this, and Ref Records said, no, you cannot, because the copyrights on the album are of Ref Records, not of Demon Dash. So you cannot do that. You can exploit the copyrights. Same happened with Recording Industry Association of America, who stopped hitpiece.com a couple of months after its launch, because the platform was releasing NFTs related or dedicated to songs or artists or albums without having the proper rights. Similar in other cases. Sorry. We have no time to go deeper in the cases, but I just put there some examples of terms and conditions. If you quite always see the terms and conditions of platform, this is royal.io, which probably you know. This is another platform which is only music, which is an Italian one. You will quite always see two things. One is that when you buy an NFT, you are not buying copyrights or IP rights, unless it is specified by the seller or the platform or or the offer for sale. The second is what you are buying depends on what is written in the offer for sale and possibly smart contract. So that's very important to understand what you are buying. And another thing, I told you, you have to check also the applicable law. For example, in Italy, if you say, I sell you all the copyrights related to this work, you are selling nothing because it's an ineffective or void clause according to Italian law. You have to specify the single rights and the aim, so the purpose of use of the right, or the protection of the rights, because otherwise they have transferred independently one from each other, and if you are not including them, you are not transferring them. This happened, for example, for the case of Miramax against Quentin Tarantino. Quentin Tarantino was releasing this in the cinema industry, but it's very similar. He was releasing, and then I leave you the floor. He was releasing some NFTs related to unpublished scripts of Pulp Fiction, but Miramax said, we have an agreement dating back 1993, and there is nothing there that gives you the right to do that. The rights are of Miramax, not of Quentin. So they discussed about the interpretation of the agreement. So the other thing to bring home today is be careful with agreements, and if you have old agreements or you want to do something, just check if you have the proper clauses inside the agreement, or otherwise update them, because they are very, very specific, at least in Italy and Europe. The common law system is a bit different. Last, but it's what we are saying, don't forget to check ownership and legitimation. If you're the minter, check first what you want to do. Second, if you have the rights to do that. I cannot, otherwise you will fall in the cases of ETHPiS or Demon Dash. If I want to create an NFT and sell it, connecting it to right in a song, I shall check that I got the right to do that from the right owners. That may be many, because if you think about music, you have the rights of the performer. So the singer, its performance is recorded, so the track is a recordal of the singer performance. They have rights on that. Then you have the rights of the publisher that may have the rights of exploitation, all or part, if there is an editor, a publisher, music publisher. Then you have the rights of those who recorded the track that may not be the same of the same entity as editor, music editor. Normally they are, but not necessarily. Then you have, at first, the rights of the composer of the lyrics and of the music. So you can see that there are many rights. And then you may have more people who composed the lyrics or the music. You can have more performers, so even more people to coordinate. And they may have collective society management of part of their rights. Maybe part of them with a collecting society and part of them with another collecting society. Maybe at international level, so each country has its own collecting, as probably you know, and you were saying it's very difficult to talk about it because it's a lot of stuff. So you have national rules, international rules, coordination among international entities, various players in the field, and so on. So in the music in particular, it's very important to check all the stuff to be allowed to do the business with NFTs. On the other side, if you're the purchaser, you have to verify what you are buying. Otherwise, you don't know what you can do with that. And if you are buying just, for example, a credit on shares coming from the economic exploitations, for example, streaming that is doing someone else, is not income. It's not copyright itself. It's just a credit. So you have to treat it correctly, even on a, I don't know, fiscal side or whatever. What about, just the last question, what about selling shares of ownership of copyright to the people who are buying NFTs? I mean, you could, for example, divide the rights or ownership on a song and sell it as like property, but you can do it also on copyrights. So you have the right to, for example, the copyrights for streaming, okay? So exploitation through streaming, and you are parcelizing it in shares, and you sell each NFT connected to the shares. So you have many people who buy and are co-owners of the copyright. Is this something that you would think about and you think it's very interesting or not, and why?
Sorry, we need like a, we deeply need like a template that it's global by default on top of every regulation. That when you buy it, it's attached to the element that you're buying, independently that it's like representing the rights or the copyrights or the digital distribution or whatever. But that template that lives on top of its jurisdiction, that can be tokenized as well on part of, in this case, the song, representing what we are buying. That marvelous template would be really nice to have it like on its final version, let's say it like that, at least for me. And for you guys that you're lawyers.
Thank you. Well, it's very interesting. Thank you. From a legal point of view, what I would say is probably it's not convenient for both the sides, for the legal implications, because the right owner is some way diluting some copyrights and transferring to people who are probably not able to exploit that copyright, like for example streaming. So you are selling your copyright, your right to economic exploitation to streaming to a person or many person. It's even more difficult to let them take a decision, but maybe DAO can help. So you put together all the technology, you can deal with it. But there are people that probably are not directly able to really exploit economically the song. While a publisher, for example, if you're selling and transferring this right to a publisher, they have all the channels, all the way to do that, as the structure and whatever, to do that. So if you expect that this brings you economic exploitation of the song, probably it's better to give it to someone who knows how to do it. But maybe you can find a way to make it work, even with other people. But if I think people like me, I would not be able to just having like 10% or 5% of shares of copyright for streaming to start going around and exploiting it in the supermarkets and then for other stuff, radio and whatever, online radio, sorry, because we talk about streaming and whatever, platforms and Spotify and whatever. I'm not there working on that. I mean, I just bought something and I expect to have some returns. But basically, it depends on the project. Obviously, there may be the ways to make it work. The other issue is that from after the last reforms of copyright, in order to protect the copyright owners, what happened? Copyright owners may terminate an agreement if they see that people who bought the copyright are not exploiting sufficiently this copyright. And on the other side, the person who bought this copyright shall exploit it and shall update from time to time on the exploitation the copyright owner, the right holder. So it means that they would have to track all the things I'm doing, all the streamings and whatever, as labels do. I mean, as labels do, as publishers do. And that's very difficult for a person, especially if it's just one small share of copyrights. So, or you find a way to automate all this stuff and engage these people who are buying the shares, or otherwise it is a bit risky. In such a case, probably it would be better to just limit to the ownership of the property, not the copyrights. But it depends on the project, of course. It's just a legal implication that you have to know and deal with. And it's not, you cannot do that or you can do that. It just, if you know that, you may address it and find a way to make it work. Just with this, I leave the floor to, I'm just going rapidly to the final part because we already talked about that, even if we didn't go deeply into the cases. That's me, more or less. And I leave the floor to Antonio. I thank you very much for
Thank you, Leo. Just 10 minutes, because also Leo, thank you to share this stage. The stage is yours. Thank you to share with me. Just 10 minutes. I say no, 5 minutes is better.
But I think this is the most important, or the most interesting part for those who are trying to deal with NFTs projects?
Maybe, yes, maybe. Yes, we are lawyer, so we'll see the legal aspects. But I think that an aspects that we want to underline for your guys, the entrepreneurs, because you are the entrepreneurs. It's important, I think, also based on my experience. The legal aspects are important because they are cost. So when you draft the business plan of the project, you will pay attention to all the costs, marketing, IT, ECT cost, how we will sell the project, so the commercial cost, and also the legal aspect. So if you know before the legal aspects, maybe, and the legal aspects cost, maybe it will be better. I don't know. It's like when you go to the shop and you say, okay, nice this yellow shirt. The second question is, but how much it costs? And so to face off with the cost, the legal aspects are also important. This, I like the chart. So this, in this chart, you can see how different role and how different rules will have and may have the NFTs. So it's important to for the entrepreneur to dress, legal dress the NFTs in order to understand the regulation that may apply. The NFT music may be a financial product. The financial product is an Italian peculiarity. It's similar to the financial instrument, but the financial instrument, so you can see here in the chart, is something that you can market and you can negotiate. It is a standard, so something, the NFT, when the NFT is more than one, and it's standard, and you can negotiate it, maybe it will fall in the financial market, and so it's a financial instrument. Instead, the financial product is something that you can add on the financial product is something that you can add to the financial instrument definition, and it's simply something that provide to the client an investment. So maybe if you acquire a product or a service with an objective of investment, maybe you fall within the scope of the financial product. And also we have, the NFT is an asset, is an intangible asset. It's maybe a means of payment, like in the form of bartering. And also if it is a means of payment, maybe there are some regulations that apply. Or maybe it's relevant rights, the ticket. The ticket is regulated. Also the ticket that allow you to access to the concert, the ticket that allow you to access to ETHMilan, it's a relevant rights. And if the NFTs fall within one of these legal aspects, maybe will happen this. This is another chart. Maybe also this, I think that is the chart that the NFTs entrepreneur will have like a picture in the room. So when you wake up and say, all of this rule, maybe.
Before the business model canvas, you need this one.
Yes, these are the potential rules that may apply. But there is a positive aspect. Maybe you can see this chart here. Maybe there is no rule that will apply. Maybe you have the opportunity to stay in the middle, and so say, okay, no MiFID, no MiCAR, no rules. So no rule, it's a simplification. You will apply simply the rule of, for example, in Italy, the civil code, the consumer code rule, so no other strange rule, but it's the simple rule that you have when you sell a service or a product by an e-commerce.
It's a matter of interpretation. He was saying before, code is law, it's not really true. That actually, it's not just, since there are no specific rules where you can code whatever and code is the rule. It's not so. If there is no specific rule, you have to interpret the existing rule and try to understand which one best fits with the case you have, which is not expressly ruled. So it's not so, it's very important to clearly understand where you are in order to be on the safe side. Sorry.
No, thank you, Leonardo. Yes, this is the aspect, the relevant aspect. You have a question? Okay.
Thanks. MiCAR, you mean MiCA, the recently approved European regulation?
Yes.
So the first question is, isn't MiCA overruling national regulations?
Maybe no, because I think the first aspect that I have learned in this this recent year is that if the entrepreneur have a clear rule, so have a legal framework that is clear, maybe it's better because, okay, I apply MiCAR. And so this is the rule, I have to respect this. Before MiCAR, so if we delete this circular chart, there is a gray zone, a gray area, in which, okay, I'm not a financial instrument, so I fall out of the scope of MiFID II. I am maybe NFTs that yes is used as means of payment, and maybe I am a money token. I file within EMD, that is the Electronic Money Directive, that is more complicated than MiCAR. With MiCAR, the European legislator cover this gray area, giving a clear identification to several aspects. And also the MiCAR regulation for the NFTs clarify if the NFTs is really unfungible and really unique, you will stay out of the scope of MiCAR. So this is the blank area of the NFTs without any regulation. But also there is an opportunity with MiCAR, because if you are also standard, if you issue an NFTs that is standard, not unique, unfungible, fall within MiCAR and not under the MiFID regulation, and not under financial products.
Okay, we'll possibly discuss later. I mean, in my understanding, MiCA was a very long pan-European effort to homogenize the national legislations, no? And the end result that says, I mean, MiCA, NFTs are not, are specific. They are not to be considered financial products, no? Which is, on the contrary, one of the delicate aspects when we are under the American, the US legislation, was considered to be a success. No, so pan-European approach, liberal approach, and saying 90%, 95%, 99% of times it's not going to be a security, okay? So you don't need an info memo when informing the potential investor that is buying an NFT. But I have a point. One of the obsessions from the US is, I mean, if you're making an investment that is providing future royalties, you are de facto promising an income, and at this point you are placing a security, okay? And if you are placing a security into the market, you need to inform your investor, okay? All the, and this is a question to the panel, no? All the NFT redesigns of the industry basically sell a stake into future royalties to some stakeholder of the industry, no? And I mean, I'm subscribing into the NFT. I'm not buying the copyright of the song, as you're saying, but I'm taking a future cash flow that is deriving from the income, no, of the song. I can take some of these rights to finance a new song and a new art project. I can swap this stuff, and so potentially all these things very much under the US regulation. Question is it also true under MiCA? Are borderline, aren't they?
Yes, also adding, I agree with you, yes, with your, what you are saying, because you adding another regulation is you create other gray area, maybe. But for MICAR in Italy, this is only for Italy, MICAR it's a regulation, so the regulation is yes, self-enforcement in all the European member states. Yes, without specific national rules. But in Italy, we are different in any case because we have provided a national rules that harmonize all of the Italian regulation to MICAR. So MICAR directly apply in Italy. But also we have this, I can say yes, harmonized regulation that say that if you fall, so your project, your entities fall within the scope of MICAR, you don't apply the financial product rules. So this gives you a certainty, say, because the most gray area is the financial product. The financial product that is similar in the US, because in general, say, lots of also the recent Italian court say that also if there is a potential investment, you fall within the financial product. So also a personal element that is something that it's also complicated to prove. So, but this is the Italian court. In any case, so we have these decisions. But we have this aspect that for me, that I think that for the entrepreneur is an important aspect. That Italian regulation, there is a specific article in this legislative decree that is issued recently, just 1 week ago, that say, okay, if your project, if your entities fall within the scope of MICAR, you don't apply the financial products rules, and this maybe simplify most of the aspect of the problem of the entrepreneur. So yes, no, I don't want to go in deep with all the regulation, but this is a chart that maybe we will face in the next project. But I'll give you some space to your question, also to explain your project. Maybe it will be nice to understand and exchange some information each other.
So, regarding the
this, no. Sono troppo dietro. Ah, it's fine.
it disappeared.
Maybe the chart with all the regulation is better.
Okay. No, your contact is good as well. So the question was, the question was like around, as he was mentioning, if I understood correctly, and that's around like clarification would be amazing. If the works that you are tokenizing are already done, and the rights regarding the exploitation of those, like if it is the streaming agreement or if it is just the copyrights, and we are not like specifically in detail what would mind for the copyrights aspect, but just for the streaming. But if the works is finished and you are tokenizing something that it's already finished and there's no improvement on top of that works, which fits really nice for music, it changed the rules really on a really positive way, specifically in the US, and I don't know how or where it fits on Europe. That's first question. And second question would be like, if that legal agreement happens on the exploitation of those future rights, and it's tokenized and attached to something that it lives on chain, if we would say, what happens if the asset could be used as well in other means by the idiosyncrasy of the Web3? Even if you've signed that agreement, what happens if it has other uses? Yeah. From whomever who bought it.
I maybe intercepted the problem. Yes, there is an aspect. Yes, the DeFi, all that comes on the DeFi is not regulated. You can regulate it with a specific rule. Maybe you have a local rule for the Italian jurisdiction. I can say civil code, consumer code. When you issue a token and all of the terms and conditions as defined, incorporated in such token, the problem is that there is a seller. So if you have a platform that offers such tokens, the problem is of the platform. I make you an example. For example, Bitcoin. Bitcoin is already issued 10 years ago, and you can use it as a mean of payments, as a financial instrument, as a financial product, and something similar. With Mikar, the problem will be of the platform that allow the exchange of Bitcoin that will apply Mikar rule. And so the problem is of the seller, the exchange, the e-commerce, that own the wallet, and also who face with the final clients. If you are, then there is an aspect that apply for all of the regulation in Italy, and I think also in all over the country. If you act, so you are an entrepreneur, if you act on a professional basis, this rule will apply. If you are a private and you decide to sell your art NFTs or music NFTs, you are a private person, and you can sell it to Leonardo, to Antonio. It's like an acquisition of a building or a T-shirt in the shop, because you act on a private basis. You are a consumer, not a professional. If you act as a professional to serve clients, you apply these rules.
But if you are an artist and you sell your royalties to a fan, are you professional or are you?
It's a different point of view. From the point of view of the financial regulations, it's about who is doing it professionally. So the platform, for example, they say if the artist who is doing every day is. Ma non rientra. Okay, and the artist doesn't fall there. But on the other side, you don't fall there. You don't meet Antonio, but you meet me, and I'm waiting there to sue you. No, I'm joking, because there's that aspect. But as we said before, there are many legal issues involved in various fields. That's the reason why we are true today. But there may be others as well. And there are the issues related to copyright. So basically, even if financial regulation does not apply, copyrights will apply. That means that if I take the picture or the song, okay, the song that is circulating to NFT, I copy it, and then I start using it, exploiting it, whatever, and I have no rights for doing that, I'm infringing. If I buy something from one who has no rights for selling me the rights, so that's more important to see the chain of rights behind who is selling me the NFT, and I'm continuing selling it. That's true that I got it from someone else, but but at the same time, he is infringing and I'm infringing as well. So basically, I take a song of Justin Bieber, I put it, I mint it and sell it through NFT. I'm not Justin Bieber, I'm not the label and whatever. They discover me, they can sue me. But then I already transferred it to you and you're doing the same and transferring again through NFT. So we are all infringers. And copyright laws allow you to stop all the people in the chain of infringement. So from the platform to the final purchaser or reseller, and all the chain, all the rings of the chain. That's to be coordinated with the platform rules, because platform rules will not allow you to do that. And that's another issue related to the fact that when you buy a physical object like a CD-ROM, you become owner of the property of the CD-ROM, but you have no exploitation right of on the content, on the creative idea, which is the work, the artwork. When you're dealing with digital stuff, which has no physical support, it is debatable. If you say that you are buying the ownership, it's something. If you say that you are not buying the ownership, you have to understand what it is. Probably it's a license. You will find in all the platforms, probably even yours, I believe, that it is said that you buy the file and no copyright, and that people in the platform get a non-exclusive license to use and communicate to the public and transfer and whatever the content related to NFT, which means you are buying it, it is public, other people can listen to it, you can get money from selling it again. You are allowed by the platform, because the terms and conditions, from the moment the people mint NFT, so put the stuff, the asset inside the platform, and all the circulation to the platform is authorized, because from the first one to the last one, all accepted the condition of the platform. That means that if you're selling the NFT or you're offering the NFT, it's with the NFT goes also the license to communication to the public. But you need this because communication to the public has no exhaustion of rights. That means that if I buy something which is just license of communication to the public, like it was decided by Court of Justice in ebook field, I have no right to resell it, okay? Unless I'm authorized from the right owners, the platform, or whatever. I have no right to resell it. Why, if I buy a book or a CD-ROM, I buy it, there is the artwork inside, but it's physical, it's property on that stuff. There is exhaustion of rights because there is no communication to the public, or, and so I can resell the used stuff, the second hand. That's something we could do with physical stuff. This is something we cannot do with digital stuff. Now, with NFT, there is a third path, a sort of third genus, a third subject or third object in the middle. It's not purely physical, it's not pure digital. It's a digital stuff which you can identify and transfer and whatever as it was physical. And people who are doing this applying the same reasoning, the same interest they have in the physical stuff, not in the digital. I mean, you're not buying the NFT of something because the content related to NFT is always copyable and pastable and does not get ruined by that and so on. You are buying it because of the certificate of ownership, let's say, or because you want it as owner, as you do when you buy a physical stuff, a physical artworks, let's say. Okay, so that's in the middle. So what applies here? We're still discussing. It's not clear.